Have here. I see Deborah Winslow.
Yes, good morning.
Good morning, and you were here for the pretrial with Nelson Mandela and Nahimana Emanuele.
Yes, and we did have a chance to speak in a breakout room, and we have a proposed pretrial statement that I typed up, but I don't know how Your Honor
Okay,
wants
very
to proceed.
good. Okay, well, if you've completed the pretrial statement, you can just submit it to the court by emailing it to Judge Simmons courtroom
Okay,
at lansingmi.gov.
and we're hopeful we're going to work this out as well, Your Honor, but I just kind of typed it up in a format and went through it with the defendants, and then we were requesting, 90 days discovery, and I put that in there as well, so it won't
Okay,
have
sounds
signatures on it, but if I
Did you
can
submit
email it.
We have a standard form that we use, and we can email it to you if that works.
Actually, I kind of had one from before that we typed up. It's like,
Oh.
it looks like a pleading, so it's kind of, it
That's
follows
perfect.
exactly along.
Okay,
But-
that's perfect.
Okay.
And so, Mr. Mandela and Mr. Emanuele, did you have any questions about the joint pretrial statement today?
No, we just ask if you could give us more time.
More time for what?
More than the 90 days.
For discovery, you mean?
Mhm.
Why do you need more than 90 days to do discovery?
Because I might not be in the country after 2 months or 2 months.
Okay, so your expectation is that you're leaving the country. Are you leaving for a temporary period of time?
Yeah, I'm just visiting. And I'll be back probably in 2 or 3 weeks after I leave.
When are you supposed to leave the country?
Can you repeat that, Your Honor?
When do you, they're in the building? Okay. When are you supposed to leave the country?
March.
What date?
Not sure yet, but it's March. Probably
Probably what?
the beginning of the month.
Okay, and how long are you anticipating you're gonna be gone for?
4 weeks.
There's something going on with the signal. You said how long?
4 weeks.
4 weeks, so for about a month. So you're asking for an additional month on discovery?
Yes.
Okay, I have no problem with that. Is there an objection to that, Ms. Winslow?
No, not at all.
Okay, we'll give you additional time, and Ms. Winslow can have that reflected in the joint pretrial statement. Did you have any other questions as it relates to the joint pretrial statement today?
Your Honor.
Okay, and Ms. Winslow, how quickly do you think you can get that sent over to the court?
I can email it over. It's in a Word format. It's Judge Kristen Simmons at lansingmi.gov.
Nope, you want to send it to Judge Simmons courtroom.
That's it. Sorry.
No worries. At
Courtroom.
lansingmi.gov.
All right, I can email that over right now, and it's in a Word format. So.
Okay, very good. Mr. Mandela and Mr. Emanuele, if you can stop by the courtroom, I'm going to have you sign it while you're here. Okay.
Okay.
Do you want me to sign it? I can print it and scan it, and I can sign it as well, or is my...
Yes, if you could do that, that'd be perfect.
All right, it'll be coming right over. Thank
Thank
you.
you. Thank you. You're all set.
Thanks.
Are they on our iPad? Oh. Mr. Smith, you were here on a discovery matter for Amanda Herbert and Aaron Jolly.
Correct. There's also a follow-up on a Lorenzo James. It's a review hearing. You had given him some time for docs, but Amanda Herbert, correct, she has been subpoenaed for a creditor exam today.
Okay, I don't see that they appeared.
As it relates to Herbert, I can file a motion to show cause. She was personally served November 25th with a subpoena to appear today. Has failed to appear. I can submit a motion to show cause on the Herbert file. Mr. Lorenzo is a different matter. This creditor exam dates back to May of 22. Failed to appear. Show cause hearing in July. Control date was set after that for tax returns and 6 months of bank statements. You ordered him in October on the 19th, still didn't produce documents. The 6th was a follow-up date for returns, bank statement, still no docs. And as we sit here today, Your Honor, I don't have the documents and he hasn't appeared. I don't think I have any choice other than ask for a bench warrant at this time on that file.
Okay, yep, I see the failure to appear back in May,
Yeah.
show cause in September. Okay, sounds good. Bench warrant can issue on that.
Okay, as a point of reference for bond consideration, current balance on the judgment, $5,512.31. Where would you like me to set the bond on that, Your Honor?
25%.
We will take care of that and submit. Appreciate your help. Have a great day.
Thank you. Have a good one. Okay, moving right along there. Did Mataloni take care of this matter already?
Got a call from his assistant, said he was logging Susan Cody's on the record.
Did the other party?
Yes.
The two?
Chelsea.
Oh, it's an attorney here on behalf of the defendant.
Yeah.
Okay, well. We'll see if it comes a little bit later. I see Ashley Nonis Hartman here on an objection matter. Antonio Bertley is present as well. 13. Ms. Nonis Hartman, did you and Mr. Bertley meet privately before I took the bench?
Unfortunately, Your Honor, I don't know if it was my phone or system, but I couldn't get into the breakout room, so we were unable to do that. I'm not sure if it would be beneficial anyway, and I can apprise the court as to that when we go on the record for it.
Looking for the objection to that. Oh. We're on the record in the matter of Pegasus Portfolio Services versus Antonio Bertley. File number is 13000806 GCE. council appearance.
Good morning, Your Honor. Attorney Ashley, known as Hartman, P77029, on behalf of plaintiff.
Okay, and Mr. Bertley, can you please state your name for the record?
Antonio Bertley.
State the date and time set for a hearing on an objection to an income tax garnishment. Mr. Bertley, you filed this objection here. It's dated for November 30th, 2022. And it indicates that you object to the writ of garnishment that was issued back on September 9th, 2022, because the writ was not properly issued or is otherwise invalid. You gave the reason that the debt is not yours and that your identity was stolen and that this debt was the result of that. I previously asked if the parties had met before I went on the record. Ms. Nonis Hartman, you indicated you would advise the court as to why you didn't think it was meaningful to meet.
Right. So, Your Honor, like I had stated, unfortunately, I couldn't connect to the breakout room. But a little background on this case is that Mr. Bertley, back in 2013, when we had filed suit, did contact our office. He did allege fraud at that time. Our office sent him a fraud packet that he never returned. He also did not file an answer with the court, so therefore a judgment entered. After we did an initial garnishment in 2014, he also contacted our office alleging the same. We sent him a fraud packet. He never filled it out. The status of the account went inactive in suspended collections from 2014 to 2016 because the defendant was active military. And then from then to now, we did not really hear anything from the defendant until February of this year, when we sent out a Reg F letter. And same thing, he alleged fraud. We sent him a fraud packet. He didn't fill it out. So we're here today. His objection under the law is invalid, but he did finally provide, it looks like, a police report, which I have forwarded to my client for review. So I'm still waiting to hear back from client on that. And it creates the conundrum where we are definitely investigating his claim for him, but the objection under the court rules is invalid. So unfortunately, that has to be denied today, but I am following through with the investigation for his claim. So once we have a result from that, either we're going to move forward with collection or we will file what we need to file in terms of releases or, things along those lines. But as of today's hearing and the objection, unfortunately, under the law, it's not a valid objection.
Okay. Mr. Bertley, essentially what the council has said is completely accurate. Your objection is that the garnishment was invalid or issued improperly because the debt you allege is not yours. Under the court rules, and that's under Michigan Court Rule 3.101, Section K, it issues or it gives you the reasons in which you can attack a garnishment. It lists very clearly what reasons you're allowed to use. And one of the reasons you cannot use a objection to a garnishment to try to attack the judgment. And that's what you're trying to do. You're trying to say the judgment is invalid. This is a judgment from 2013, 10 years, a decade old. You failed to appear. It wasn't that you were not aware that you were being sued. That sounds like you knew. You failed to appear, meaning you didn't file anything with the court. You could have filed and said, this is not my debt. Any of that would have worked. You failed to appear. You failed to respond. A default judgment was entered. And here we are a decade later, and the plaintiff is seeking to get recovery under that judgment. It does sound like, however, in your to your favor, that they are still willing to work with you to try to resolve it, because it sounds like you have some evidence that you were a victim of some fraud. But as it relates to the objection that you filed here, under the law, I cannot grant it. It's an invalid objection. So your objection is going to be denied at this time. Okay, sir?
Yes, ma'am.
Okay, and so you should still work with the attorneys for the plaintiff to try to resolve this in another form. It just can't be resolved through an objection. And it's unfortunate that it did take you this long to get that packet and information to them, because it's probably could have been resolved a while ago. But nonetheless, you're doing it now. Hopefully it gets resolved. But at this point, I'm going to deny your objection as invalid under the law. Do you have any questions at this time?
No, ma'am.
Okay, any additional matters for the record today, council?
No, thank you, Your Honor.
Okay, you're all set. Thank you. Put Mr. Mataloni in the room. Okay. Did I give you the file for that already?
For this one? Yes.
Okay, we're on the record in the matter of Empire Motors LLC versus Jalen Woodard. File number is 22-02468 GC. Council, may I have your appearance, please?
Good morning, Your Honor. Nal Chat Francis on behalf of plaintiff's attorney of record.
Okay, Mr. Woodard, you are present. Do you have an attorney?
No, I don't.
Today's the date and time set for a hearing on a motion to set aside default judgment. Did the parties meet before I took the bench?
We did, Your Honor. We were not able to come to any resolution.
Okay. Mr. Woodard, you filed back on December 20th, a motion to set aside default judgment. Default in this matter, it looks like it entered. Back to December 12th, let's see. December 15th, you 5 days later filed this motion indicating that originally this case was in the 46th District Court in Southville, that you submitted paperwork to that court that was received on November 3rd, 2022, and that you were not notified of the court change. You said you were not able to submit your documents to this court, which is the 54th District Court, and you would like the judge to hear your side of this case and to review evidence that you made payments to the plaintiff. Was this case originally filed in the 46th District Court?
Yes, I was.
Okay, I see where it was received in 46th District Court back on September 9th. And Mr.
Yes,
Woodard,
sorry.
you responded at that time to the 46th District Court is what you're saying?
Yes.
Okay, I don't understand why you couldn't stipulate to set aside a default then.
Your Honor, we don't have any notice that he did respond to the other court. He did send us a letter in December after the judgment was already entered. So Your Honor,
I would imagine if you're being reasonable, I would imagine that if he was served with a lawsuit indicating that the lawsuit was for him to appear before a court in a totally different jurisdiction, and as indicated here in my file, it was transferred. think it would be reasonable to make a stipulation to set aside a default. He's appeared now, obviously trying to address the issue, and he's made a statement here indicating that he was noticed that this was before another court and he sent documents there. And now he finds out it's here. I'm granting his default, his request to set aside the default judgment.
Thank you, Judge.
Okay, this matter will be set for a pretrial. I don't know if you filed an answer, but you need to file one, sir. Did you file one in the 46th district?
I didn't get a chance to. Once I found out that it was moved to this court, I stopped communicating with that court, and I've been trying to get everything back in your court, Judge.
Okay, I'm giving you 14 days to respond to this complaint. You need to file a response in writing. You send it to the court within 14 days, as well as a copy to the plaintiff's attorney, okay?
Okay. Yes, Judge. Thank you.
And the court will mail a notice for the pretrial date, Your Honor.
Yep, you'll receive one from the clerk's office as to what your date for pretrial will be. And Mr. Woodard, I just want to confirm that your address is at 4017 Wood Creek Lane.
Yes, ma'am.
Okay, do you have any questions at this time?
No, ma'am.
Any additional matters for the record, counsel?
No, Your Honor, thank you.
Thank you, you're all set.
Thank you, Judge.
You're welcome. Okay, I see Ms. Leonard and Mr. Mataloni have returned. Did you all complete a joint pretrial statement, or do you plan to complete one?
Judge, the counter complaint jurisdictional amount is a circuit court jurisdictional amount. So we agreed opposing counsel was going to file it in removal to circuit court. And I wouldn't argue the point, obviously. So
Okay, sounds good. Counter complaint. Okay, and so Ms. Leonard, you're gonna file to have this transferred to circuit court, correct?
Correct.
Okay. Okay, I'll have that noted in the file. You're all set for today.
all right,
Thank you.
thank you. Sorry I was late, Judge.
You're fine. Have a good one.
Yep, thank you.
What's your name, sir? Okay. Did we see Samuel Benham?
Nobody appeared for that
Nobody appeared. No one appeared for the plaintiff?
on both sides.
Judgment submitted appears excessive. Okay. Well, Be seated. On the record in the matter of Raj Jaffer versus, is it Shanika McKissick? File number 22-01957, council appearance.
His court Andrew Moore on behalf of the plaintiff Roz Jaffer.
Felicity Till, P 83961, appearing on behalf of the defendant, Shanika McKissick.
Is Shanika McKissick here?
She is not. I just checked the hallway for her. I have not seen her. And I will be making a motion to withdraw on the record today pursuant to NCR 2.117C2. There has been a breakdown in the attorney-client relationships, such to the point that I represent her further in this matter.
Okay, have you been in communication with her recently?
Yes, I talked to her yesterday. She indicated that she no longer wanted me to represent her.
Motion to withdraw is granted. Today was the date and time set for a bench trial. And the matter was scheduled for 9 o'clock. It's 9:38. Ms. McKissick has failed to appear.
Yes, Your Honor, given that the defendant's attorney has withdrawn, the defendant has otherwise failed to appear, I request a default judgment entry in order for an eviction immediately. And
A default
a money
judgment.
judgment as well.
Default judgment will be granted. Why are you seeking immediate grant?
I'm seeking the immediate writ because I believe that there was some settlement negotiations about vacating the property without a money judgment. Obviously, that's broken down. This case has been going on for approximately 7 months. The first time we were here, I think the defendant requested a bench trial or a jury trial, which was denied. The second time she got an attorney, and the attorney wanted a delay to get information. I don't know what kind of information was actually obtained by defense counsel. And now the defendant has failed to appear. I think her intent in having her attorney withdraw was to further delay these proceedings, again, in kind of an effort to continue to retain possession of the premises and having not paid rent since 12 months ago.
It'd be a bad plan to have your attorney withdraw on the day of the trial
The
and
eve
then
of
not
trial,
show
that's-
up.
That's a great, yeah, it's a great plan.
Terrible plan. It's not how you get more time.
Well, I'm hoping that you're not inclined to give her, obviously, we're willing to give her some time to vacate the property.
I'm just giving her the statutory time frame. If there was a reason why the property needed to be secured because of you maybe thought there was no utilities or something, then I'd give you an immediate writ. But just because the case is dragged on, that's how litigation works.
Sure. So if you're inclined to give it the statutory time, that's perfectly fine.
Yeah, the writ will issue in statutory time frame. There was a K is selected here on the supplemental complaint for a money judgment. What is the amount?
So this back rent from January, the defendant's portion totals $1,783. We do have documented damage to the property, including violations of the lease in terms of maintenance of lawn care, trash removal totaling $840 in damage to stairs, garage door, windows, front door, lawn care that the landlord had to pay in violation of the lease, $600, trash removal of the garage, $725. There were missing smoke detectors, lights in the, do you have receipts for this amount? Okay, so disregard the missing smoke detectors, and there were court fees that the landlord incurred, including service of process of $32.58, and I believe there was a filing fee. I'm not sure, $143.52 doesn't sound like the filing fee, but maybe for a certified copy.
Okay, sounds.
Total is $4,155.52.
$4,100
$55.52.
and can you prepare an order for the court
Yes, Your Honor.
under the 7-day rule. Very good. Judgment will enter by default in favor of the plaintiff. Any additional matters for the record? Well,
Not on my behalf.
she's no longer the attorney, so.
She looked like she wanted to say something, but that's okay.
Her motion's been granted as well.
Thank you, Your Honor.
Have a good one.
Which one?
It's right here.
Oh, yeah.
You gave me copies. Let me just sign two. You can give her one of them.
Oh, well, you can keep that. I have a nice one.
Just like that. We're done for the day.
Not done yet.
I know. Oh, I like the.